record. Okay, we're on the record calling docket number 21-UST-EA-02, Department of Health of the State of Hawaii versus Respondent, United States Department of the Navy. This is a continued evidentiary hearing on the merits and closing arguments. May I please have appearances of counsel? Let's go in order. Mr. Hargrove.
Good morning. This is Wade Hargrove, Deputy Attorney General for the Department of Health.
Good morning. Ms. Gannon.
Good morning, Hearing Officer Day and Counsel. My name is Ella Foley Gannon. I'm with Morgan, Lewis & Bacchius. I have my colleague here, David Brown, also of Morgan Lewis, and Jeff Lau of the City and County of Honolulu. Also in the room with us here physically is Uge Moman, also from Morgan Lewis, and we represent the Board of Water Supply.
Thank you very much. Now, Mr. Henkin.
Good morning. My name is David Henkin. I'm an attorney with Earth Justice, and we represent Sierra Club.
And I did forget to mention that Erwin Kawada, our client representative of the BWS, is also in the room.
The figurative room.
The virtual room, right.
Mr. Jensen.
Good morning. My name is Craig Jensen. With me in the room is Dave Fitzpatrick, and with us virtually are Marnie Riddle and John McKay, and we represent the Department of the Navy in this matter. Thank you.
Okay, we're going to do just the final housekeeping matters regarding exhibits. Since yesterday, I believe now, we have exhibits filed that were supplements to the record. One from Sierra Club, that was exhibits. Let's see here. Just say it for the record. Exhibit S30 or S40. We had, and that's been uploaded to the database with an amended exhibit list. We have with BWS, let's see here. So 4 exhibits, and this would be, I believe, you correct me if I'm wrong, this is B422, B423, B424, and what is the fourth one?
B361.
B361. And these have been uploaded into the database?
That's correct.
Okay, and we have an amended, updated exhibit list. And then just before we got on, we received an amended exhibit list from the Navy with exhibit N-7N added to the record. And I believe that has been uploaded, correct?
That is correct.
Okay. Is there any other exhibit that needs to be added this time besides the motion to admit exhibits that we had, that was just filed this morning?
Not from the board.
Not from Sierra Club. I should mention that Sierra Club representative Wayne Tanaka has just entered the virtual room.
Okay. Thank you. Welcome. Welcome, Mr. Tanaka. Okay. Seeing none, let's just move on quickly to the motion to admit exhibits that was filed this morning by the Navy. This is exhibits N-70 and N-7P. This is a request to supplement. I'll just go around. Mr. Hargrove, any objection?
No objection. Thank you.
Ms. Gannon?
No objection.
Mr. Henkin?
We're deeply concerned that we did not have the opportunity to see these exhibits during yesterday's proceedings, that we were deprived of the opportunity to cross-examine. Just wanted to say that for the record. Our position is that the truth is on our side in this proceeding, and so if these are materials that the Navy wants to present, then we have no objection. So
noted. Without objection, these are admitted into evidence. This is exhibits N-70 and N-7P. The Navy can, oh, pardon me, Mr. Oh, Mr. Jensen, do you have something to say? I'm sorry.
Yes, I'd just like to proffer for the record and the viewing public that these two exhibits consist of a media release from the Department of the Navy dated November 29th, 2021, informing the public of the groundwater contaminant or of the potential for water contamination in the drinking water, and subsequently a newspaper article or an article from the Hawaii Public Radio's website dated November 30th, advising the public also with regard to this media release. And it goes to counter the claim that the Navy did not notify the public with regard to the contamination issue until the 3rd of December. Thank you.
With due respect, that's a mischaracterization of the media release. The media release states that guidance for only residents of the Joint Base Pearl Harbor Hickam military housing, so not AMR or anyone else, those people were advised by the Navy that if they smell fuel in their water, maybe you don't want to ingest it. That's N-7O. So no, it's not a general notification of the public. It's not a statement that things aren't safe to drink. It's if you smell fuel, don't drink it if you live at Joint Base Pearl Harbor Hickam. N-7P is a news report that accurately says that the Navy made that recommendation. It says U.S. Navy recommended Monday night that Joint Base Pearl Harbor Hickam military housing residents avoid ingestion of their potable water as a cautionary measure, quote, if chemical or petroleum odors are present, end quote. The news report is also accurate, saying, quote, the State Department of Health went a step further Monday and recommended that all, underscore all, Navy water system users avoid using the water for drinking, cooking, or oral hygiene. That is not with respect to if you smell anything, because if you smell anything, they also said, if you detect a fuel odor from your water, you should avoid using the water for drinking, cooking, bathing, dishwashing, laundry, or oral hygiene. That's what the Department of Health said. And it also correctly notes that the commander of Joint Base Pearl Harbor Hickam sent a message to residents in the military housing communities on Monday, reaffirming their commitment to investigating the complaints. And then Captain Eric Spitzer said that he and his staff were drinking the water. Some staff members also live in the housing and were using the water as well. So that's the information that the Navy provided to the public on the 29th, which is we're drinking it. If you smell fuel, don't drink it. Or think about not drinking it.
If I can,
Yeah, of course, Mr. Jensen. So but after Mr. Jensen, after you comment, we're just going to close it right there. Mr. Jensen, you may respond.
I would just like to point out that with regard to the newspaper article, the Navy has no control over what the news system publishes. The important point is with regard to our media release, and our media release says, not maybe, as Mr. Hickam would claim, it does say in particular, if chemical or petroleum odors are present, recommend avoiding ingestion as a cautionary measure. Thank you.
And apparently you have no control over the commander of Joint Base Pearl Harbor Hickam telling people, I'm drinking it, don't worry about it.
I'm out. That's it. Okay. We'll save this for argument. The documents speak for themselves and you can argue it at the appropriate time.
The public probably won't have access to these documents. And so Mr. Jensen wanted to put on the record what they said, and so did I.
Okay. I believe that's been done.
Thank you.
So with respect to just confirm on the record, N-7O and N-7P are admitted into evidence without objection. Those can be uploaded immediately and an amended exhibit list filed. With that understanding, I believe that is the close of all pending requests. Mr. Hargrove, would you like to add anything before we close the trial record?
Would not, thank you.
Ms. Gannon?
Nothing further to add.
Mr. Henkin?
Nothing further.
Mr. Jensen?
Nothing further.
With that, the trial record will be closed. As soon as Mr. Jensen informs us that the documents have been uploaded, I will work with our DOH staff to basically close the joint database that we've been using so that it's not subject to amendment anymore. And then we will proceed. With respect to the arguments today, we have
one question. Sorry, here, just a technical issue. Will the parties still be able to access it to
Oh, yes.
download?
Yeah, so basically it'll just prohibit uploading.
Wonderful. Thank you very much.
With respect to today, we have 15 minutes apiece for closing arguments. The order of presentation is the reverse order of the evidentiary presentation from yesterday. That means it would be first the Navy, second Sierra Club, third Board of Water Supply, and fourth the Department of Health. I would like, if possible, just to make sure that the hearings officer has what I believe to be the correct framework of what is at issue in this case. I'll just briefly state my understanding of the issues, just basically the skeletal issues in this case. And you can tell me if I'm correct or incorrect, but I think that would be helpful to me in this argument. So basically, the hearings officer views the emergency order as borne out in the evidentiary hearing as having essentially two separate, albeit related emergencies. The first is the release on November 20th, 2021, and the ongoing response. This concerns, in the emergency order, there are 5 enumerated orders, or I'll just call them the enumerated orders. This first emergency would concern 1, 2, and potentially 5. 1 concerns the immediate suspension of operations primarily. The second concerns the installation of a drinking water treatment system or systems. And then the fifth is basically about taking corrective actions. The second alleged emergency is broader and concerns the systemic problems with the continuing operation of the Red Hill bulk fuel storage tank at the current time at any fashion. And this is all 20 tanks. And this primarily concerns emergency orders enumerated as 3 and 4, which primarily concern the defueling of 20 bulk fuel storage tanks. And again, order 5 could relate to both. The first emergency or the second alleged emergency. I believe that my take on it is they seem to be separate but related. I would like a statement from each party whether they agree with that characterization or not. And with that, Mr. Jensen, if you'd like to proceed.
Yes, sir. Good morning, hearing officer Day, council, and everyone watching. To a certain extent, the evidence presented and the arguments made by the 4 parties to this hearing are like 2 ships passing in the night. On the one hand, you have Department of Health, Board of Water Supply, and Sierra Club, and they're focused on the what if this and what if that. And on the other hand, you have the Department of the Navy, and we're focused on what happened. How did the release happen? What did we do to isolate the contamination? What did we do to take care of our people? And what are we doing to clean up the mess? An emergency order must focus on what's happening now or just about to happen. What is the imminent peril and how to handle it? Today, on December 21st, here is where we are. The emergency was realized. The Navy immediately responded by doing all things that you've heard. And because of that, there is nothing happening now or just about to happen that an emergency order needs to deal with. The last release from an underground storage tank was in 2014. And in 2015, the Department of Health, the EPA, the DLA, and the Navy mutually agreed on an AOC, an administrative order on consent, to address that release and to work cooperatively to protect drinking water, the human health, and the environment. The May and November releases were not from a tank farm, or were not from a tank. They were from pipes. And there is good cause to believe, as you heard yesterday, that the 2 releases are related, because the pipe in the November release was an AFFF pipe, a fire suppression pipe, which shouldn't have been holding fuel, had to have gotten the fuel from somewhere, and most probably got the fuel during the May release. That's under investigation, but that's what we know now. My point is that these releases, or indeed one release, the May release that ended up in the pipe and then subsequently was discharged from the pipe, the AFFF pipe, do not support a what if tank release. There are a lot of tools in the Department of Health's Board of Water Supplies and Sierra Club's toolbox to address the what if. The AOC is one, and the Department of Health agreed to it. Navy's role, as you've heard yesterday, is to produce deliverables. And we've done that. For example, the groundwater model was submitted in March of 2020. They've spent a year and a half talking about it and thinking about it. We've asked for formal comments on it, which they have not yet sent. They haven't engaged in the process they've agreed to. And now the Department of Health wants to use this process, the AOC itself, and their own dereliction within it as a basis for the emergency order. The permitting process is another regulatory tool, and Board of Water Supply, Sierra Club, and Department of Health, through the Environmental Health Agency, brought a contested case hearing over whether a permit should issue. The administrative order of consent is still in effect. It is working. Department of Health and the Navy remain engaged in that process, and 6 years later, there have been no further tank releases. The best evidence that our improvements are working. The permitting process is also still underway, and the Navy, Department of Health, Board of Water Supply, and Sierra Club are still very much engaged in it. Best evidence of that, the other three parties have moved to reopen the hearing to present the evidence that you heard yesterday, and undoubtedly a great deal more, given that that contested case hearing will not be confined to the one day that you had from the Department of Health to consider the matter. But let's take a moment and address the what if. Okay, let's talk about the what if. Red Hill, as you heard yesterday, the underground storage tank system has a series of interlocking safety systems to prevent releases, and if there is a release, to detect them. And that second part is important. Tank tightness testing, you heard about that. It's our leak detection method. We conduct it twice a year, even though the regulations only say we have to do it once a year. It takes days to conduct. It's performed by professional engineers, not the Navy, contracted professional engineers. And we've done it, and all active tanks have passed the tank tightness testing system. TERM is the Tank Inspection, Repair, and Maintenance Program. It's the industry standard approved by the American Petroleum Institute, and includes the non-destructive examination that you heard all about. It is also Department of Health approved. Automated fuel handling equipment. You heard about that from Captain Meyer. These are the fuel monitoring systems that gauge the fuel, work the processes. It works. It works in September in that incident that has been reported where there was no fuel release, but there was a problem with the system. It worked. Groundwater monitoring. You heard evidence on that, and you saw graphics on that. We prior to 2014 didn't have a lot of groundwater monitoring stations. We now have more than 20, and we're working to get more. Soil vapor monitoring. You heard about that too in the Department of Health testimony. They're early warning sentinels that something has gone wrong, that there's a problem in the tanks potentially, and that there's a leak. They're counters. These soil vapor monitoring systems are counters to any claim that a tank could be leaking a small amount, and we would never know. And on these 5 systems, it's important for the hearing officer to understand, I think, that the only measure that's in the Department of Health underground storage tank regulations is the tank tightness testing measure. And that's once a year. The other systems, the other things I've just talked about, go above and beyond. Why does the Navy do it? Well, it's the right thing to do, obviously, but also because it was agreed to by Department of Health, EPA, and DLA. And it was designed to account for any special risk that might be present in the Red Hill underground storage tank system. So, and I'm going to get to your point now, sir, with regard to what does the emergency order offer and what should we, how should we think of it? Okay, we have an emergency order here. I'm going to talk about justification first, and then I'm going to talk about the directives. So we have an emergency order here without proper justification. First, the first justification cited to the emergency order are a number of alleged failings with regard to the AOC deliverables. We already talked about that. This justification is not in the form of an emergency, let alone imminent peril. There are disagreements on analysis, disagreements on experts, There's a resolution process in the AOC with regard to these disagreements on deliverables. The Department of Health has never exercised it. They can't, honestly, because they haven't even gone through the process of working it out with the Navy yet. We ask them for documents and they don't give it to us. So how can they move forward with their dispute resolution process there? That's one question, kind of irrelevant to this hearing. More relevant, how can they use that as a basis to claim that that is proper justification for an emergency order? It's just not. Second, the order lists what they allege are the 5 releases. The first, in 2014, as I already told you, was the impetus behind the AOC. A release in 2014 cannot justify an imminent peril determination in 2021, especially when the parties decided, including the EPA and DOH, decided that the proper vehicle to address that release is an administrative order and consent, which is what we all agreed to do. So that one's out. 2 additional releases, Hotel Pier and Kilo Pier. You didn't hear a lot about these, probably because all the parties recognize they're not really relevant, but I'll give you some information that you'll be able to see in the record and in our briefs, okay? First, they're pipe vents. They're not tank events. Down at the harbor, 4 miles away, they're not up here, okay? And they're adjacent to surface waters, not the groundwater, all right? So those are important points. Plus, and significantly, those issues were both addressed on a practical and regulatory matter level. So they've been addressed, they've been resolved, and they were resolved consistent with what the regulators told us to do. So no one is at risk. And then finally, you have the May and November releases that are most probably connected, as I've already discussed. Importantly, the contamination source was isolated, people were protected, and cleanup is ongoing. Okay. So third, the order cites the contamination at Red Hill, suggests the contamination may have been a result of the May and November releases, and argues that Red Hill lacks infrastructure to deal with this. Okay, got that. We all agree, okay? There was probably a connection between the May and November release. And we have very good reason to think that the November release was the cause of the contamination to Red Hill. But the Red Hill shaft is closed down and will not reopen until water meets EPA and DOH requirements. Okay, that's important, number one. And on infrastructure, DOH wants drinking water treatment systems. The Navy wants drinking water treatment systems. We've already went out and purchased large GACs and are using them right now to clean out the distribution system of the Red Hill well. And we have even larger GACs, multi-million dollars, $20 million worth of GACs on their way that we're going to apply to the wellhead once we get a permit from Department of Health, because we would not do that without getting the permit from them, and use that to flush the water, okay, out of the well, treat it, okay, and put it back into the system. So those are the justifications. I just ran through all of them with you, and none of them support an emergency order. Let's talk about the directives. Directive 1. That the Navy immediately suspend operations at the bulk fuel storage tank. Well, as you know, the Navy's already suspended operations at Red Hill, and the Navy's suspension will continue at a minimum until the investigation into what happened at the Red Hill shaft and how it was contaminated is determined. And that makes sense, okay? A forever suspension is not appropriate. Find out what happened, you make sure the processes you have in place address it, and then you move forward. That's not what the emergency order does. But importantly, with the suspension, there is no emergent need to take any other action or to take another type of expansion to protect human health and the environment. Directive 2, that the Navy take immediate steps to install a drinking water system or systems at the Red Hill shaft. I've already talked about that, so I won't, we're doing it, all right? And that's important. Another important point is, just because a provision within the emergency order is a good idea doesn't mean that it substantiates or it validates the emergency order itself. Okay. And I think that's important. Directive 3, submit a work plan and implementation schedule to safely defuel the bulk fuel storage tanks. Well, the Navy's order says instead that the Navy will develop a work plan to conduct necessary repairs. Look, we have it right. Department of Health has the cart before the horse. They have it wrong. The Department of Health has presumed defueling is necessary and worked backwards to get to defueling. Okay. We instead are directing the same type of analysis be done. And however that analysis comes out, we will do the things required from that analysis. Secretary Balaki said on the stand yesterday, if that thing includes defueling one or more tanks, we will do it. So again, we're not putting the cart before the horse. We're working as we should chronologically moving forward. Directive 4, defuel the bulk fuel storage tanks at the facility. So again, the last release from an underground storage tank at Red Hill was in 2014. And we all know that it was caused by contractor error. The Navy has a robust program to ensure that the continuation of the integrity of the tanks. The recent releases, the ones that everyone complains about, are from pipes, not tanks. And one of them was from an AFFF pipe, which isn't even a fuel pipe. Assuming there is imminent peril, therefore, which there is not, an appropriate order would address deficiencies in the pipes, not the tanks. Directive 4. I'm sorry, I just discussed Directive 4. Directive 5. Submit a work plan to determine deficiencies that may impact the environment and develop correct recommendations for corrective action. The SECNAV memo contains nearly identical language. And again, I'll make the point. The mere fact that some of the emergency orders provisions are good ideas is not the legal standard for whether an emergency order is appropriate. The stakes are high. Secretary Balaki has told you that the Red Hill bulk fuel storage facility is a critical national security asset. The burden is on the Department of Health, and they can't meet the emergency order standard. On the medical piece, you heard from Dr. McGinnis that based on what he knows, he does not anticipate any long-term health impacts. If that's not good enough for you, Dr. Felton, Department of Health's toxicologist, said the same thing. And she shared that both with you yesterday at the hearing and in public forum, at least 2 Fridays ago. And their opinion is based on medical and toxicological expertise and direct knowledge of both patient dose and exposure. And while Mr. Brown attempted to cross Dr. McGinnis with regard to textbooks, it's important to understand that he has the experience from the last 20 days, 25 days, to come and the expertise to come to his opinion. And I would note that Mr. Brown did not choose to cross-examine Dr. Felton with regard to her position. The Navy has isolated the Red Hill shaft and suspended operations at the underground storage tank facility and is taking
15 minutes has elapsed.
You may sum up.
Okay. It's taking care of people in extraordinary ways. The Navy is testing constantly and continues to confirm that the only well impacted is the Red Hill well. In addition, we're purchasing clean water or drinking water systems, treatment systems. Yes, pumping draws contamination to the wellhead. Sherry Ng told you that yesterday on Direct. And that's why we have 2 larger GAC systems, which are expected to be here within roughly 2 weeks, and for which we're seeking a permit from Department of Health that will flush and treat the Red Hill. That is so important. Once again, the Navy is not saying that the contamination at the Red Hill shaft was not significant. It was. And the Navy and I personally am deeply, deeply sorry for the impact of that contamination on the lives and the people of Oahu. What we are saying is that our efforts to address this issue have mitigated the immediate impacts and kept any further significant impacts from happening. No one is at actual risk of harm today, and there is no justification for any provision of this order. Subject to your question, sir. Thank you very much.
Ms. Gannon.
Thank you and good morning, Hearing Officer Day, Council, and the public. I'll start off by addressing the questions that you posed to us this morning. because I think that's a good framing of the issues and a good way before we go through the evidence that you've heard. You asked, is it appropriate to divide it into sort of two issues, dealing with the current peril that the people of Oahu are experiencing, and looking at the future peril that the people of Oahu experience because of the existence and operation of these worn out tanks. And I think we should start by looking at the authority of the DOH to issue an emergency order to see if that's an appropriate way to approach this situation. And I think all you have to do is look at the language that says that this authority is to address an imminent peril to health, human health and safety, or the environment that is or will be caused by the operation of a tank, underground tank system. So the legislature has already clearly addressed that that's an appropriate way to approach it. You don't have to just address things that are happening today. You don't have to just stop things when leaks have happened or when people are getting sick and animals are dying because they're drinking contaminated water. We don't have to. The legislature wisely, and as it was constitutionally required to do, said, no, we have to prevent these sort of things from happening. And there's no better example as to why that's required than looking at this situation. And I'd start off by saying also that one of the things that the board has been doing ever since the 2014 release, the board, in exercising its public trust responsibility to protect this irreplaceable water resource, took a really hard look at this system. And it took a really hard look at this system because it's, close to 200 million gallons of fuel above a sole source aquifer in 80-year-old tanks, an 80-year-old system. Just looking at that specs makes you think, wow, we really have to look at this carefully to make sure that we're not going to do irreparable damage to our aquifer and lose this irreplaceable source and right of the people to have clean and healthy drinking water. So the board has been working on this and has spent huge amounts of its resources to protect its customers and to carry out its public trust. And what all of that analysis has led us to do is to be ringing the alarm bell for years, saying, everybody, you know what's going to happen? Sometime there's going to be a leak and it's going to get out and it's going to get into the water and it's going to get to the drinking water. That could happen. We got to take actions to stop that. What did everybody say when we said that? The Navy said, no, it couldn't ever happen. Yeah, we've had leaks. Yeah, there's been problems, but we've got systems. And Mr. Jensen just referred to all these systems that are there. But again, just looking at what happened recently. And as Mr. Henkin just pointed out, did those systems stop the recent leaks from happening? Did those systems allow them to track where that fuel was going? Did those systems do what Mr. Jensen called the early warning signs so we would make sure that nobody in the public was damaged? No. How did we find out that there was fuel in the drinking water? Because people turned on their taps and they smelled it and they tasted it and they saw their dogs getting sick and their children getting rashes on their bodies. That's how we knew it, not by any early warning system that the Navy has been operating. So when we're talking about looking at an imminent future threat and the authority and the need for the department to act, I don't think there's a clearer case. I don't think there could be a clearer case because we have to be warned. We're lucky that we haven't had a larger release yet. The reason all that evidence about the problems with the tanks and the problems with the way that they inspect and repair them or do not, the problem with what happens with their pipelines, the problems with the way they track the fuel, all of that speaks to the incredible peril, the incredible threat that exists right now today. It's even with the fuel not moving, there is still 187 million gallons of fuel 100 feet above our sole source aquifer. That is peril. That is a reason for the department to act. And if you don't act, what could happen is we're going to have one of those major releases. And when that happens, we're not going to be able to clean it up. We're going to get to a point we can't even safely and quickly clean up these spills, which are much smaller than what the ABS's risk report says could very, very well happen from this facility. That is not a risk that we can afford to take. We can't wait until it's ruined to take an action. And so we applaud, and we applauded the department issuing this order and appropriately saying, we got to do things tomorrow to address the stuff that's in there right now that just happened. And we've got to take action right now to make sure that this imminent threat that is caused by the operation of this facility is addressed. And Mr. Henkin in his opening, and we in our papers have discussed why this authority is appropriate, why it applies to this situation. And we will direct you, Hearing Officer Day, to closely look at those and to closely look at the Navy's explanation for why this doesn't apply. It simply is not a correct reading of the law. It's not a correct representation of the facts, and it's simply wrong. And so in response to your overall questions, we agree with the way that you're approaching it. We agree that those are the measures that address these concerns, and we ask that you do that. We also want to address the Navy's argument that they have made and that they seem to be making throughout the proceeding by their questions and with their witnesses, was that somehow the Department of Health is handcuffed because it entered into an AOC to address the 2014 very serious leak. And that's simply not true. And that's not true from the face of the AOC. They talked about, the dispute resolution proceedings, and yes, those are in there, absolutely. And those do authorize all the parties to exercise those actions. However, importantly, and you remember we talked about this, and it's in the AOC itself, which is Exhibit B81 at BWS 008953. It says that the DOH expressly reserves its right to take, direct, or order any and all actions necessary to protect public health, any source of drinking water or the environment, or to prevent, abate, or minimize an actual or threatened release of hazardous substance, pollutants, or contaminants or hazardous or solid waste from the Red Hill facility under, among other things, Hawaii Revised Statute Chapter 34.2L. And again, you're exercising your authority under 34.2L. So that their argument that you can only rely on the AOC is simply incorrect. Now let's just walk through, let's take a little bit of time to walk through the evidence that you heard. In my opening argument, I told you that what you were going to hear was that the water has become polluted. Unfortunately, it happened, as we always feared that it would, and that pollutant got into drinking water, and that pollutant has damaged real people on the island, and that it still exists in the drinking water today, in the system today, in the aquifer today, and that the Navy's actions that they've taken, and we applaud them for taking actions to try to protect their service people. They should certainly do that. And we recognize that they're trying. They're absolutely trying. But the problem is they can't do it. Just like we know they don't want to have leaks. They want to keep the fuel in the tanks. They want to be able to use the fuel to service their fleets and for other uses. We're not contesting that. We're not contesting their desire. We're contesting their ability to be able to do that. And that's largely just because these tanks are 80 years old and they don't have the capability to service them. They don't have the capability to keep them running in good order. So that's what we said we were going to show you. And I think that's what we did show you. So we showed you that there's been contamination. We showed you there's been harm. And we showed you that harm is happening right now, and that the harm is going to happen in the future. So just to go through quickly through what you did here, we first heard from the DOH witnesses, and you heard from Noah Klein, and a couple of really important things from her testimony was that she, who's one of the people who helped write these regulations, says that the DOH has this emergency power. She also says that, again, she wrote was largely drafting the underground storage tank regulations that apply to these facilities. She says that the Navy can't comply with them. And it's not that they can't comply with the tank tightness testing. And I think Mr. Jensen seemed to indicate that was really the only thing in the ARs that applied here. There's many, many more requirements that apply to USTs, including that they have to be operated and maintained in a way that prevents leaks for their operational life. We can clearly see they can't do that. She also walked through the corrosion protections measures that are required, and she clearly pointed out they can't meet that. And then we heard from Lene Ichino Subo. I'm sorry if I mispronounced her name. And she, you remember, is the acting chief from the solid and hazardous waste branch. And she told us, they haven't inspected many of these tanks within the 20 years, some of them up to 40 years. And some of them they've recently inspected, but some of those hadn't been inspected for 60 years. And this is according to an industry standard that says that they have to be inspected every 20 years. They simply haven't done it, and they don't seem to be able to do it. We've also heard she also testified about the impacts to the Navy's drinking well, and that there were hits for TPH that was 350 times higher than safe levels. So these are very significant facts, again, when we're looking at the peril and the damage and the emergency that has and will continue to happen. We also heard from Phoenix Grange, and she was the supervisor from the Hazard Evaluation and Emergency Response Office, you'll recall. And she talked about the problems with with all the information that the Navy doesn't have, with all the things that they haven't done in their groundwater modeling, and how they haven't been responsive to the comments from the Navy. And why was this groundwater modeling so important? So that when there is a spill, when there is a leak, we might have a chance to know where it's going and to be able to address it. We simply don't have that information. So that makes the peril that much higher. That makes the risk that much greater. They simply don't have the information. And finally, we heard from Dr. Diana Felton, and she talked about the really acute and serious health effects that being exposed to petroleum has, and that there have been over 5,000 medical screenings that have happened. And we brought on our witnesses. And as I told you, Mr. Kawada would talk to you about the damage that's happened to the aquifer, and that it's possibly irreparable, and about the impacts that has on the BWS, on its customers, and on the island as a whole. And you also remember that he said that in his 39 years of experience, he had never seen a more imminent peril to drinking water in his entire career. And he told you that, and that was not contested. And then we had Dr. Norfleet, who testified, and he testified about all of the problems at the facility and all of the problems with the way that they do their term process, and the way that they simply aren't able to identify where the problems are in these tanks, so they can't address them. And he talked about all of how the risks are really underestimated, and that importantly they're at the end of their useful life. And then we got to the Navy's witnesses, and you heard Secretary Balaki talk about the emergency order. Without the emergency order, the DOH is not going to have a role in telling the Navy how it has to interpret the Secretary's order. And as Mr. Hagan talked to the Secretary about, the Secretary could also suspend that order whenever it wants. So it doesn't address the peril. It doesn't make sure that it's going to be addressed. It leaves it in the Navy's hand. And we talked about with Captain Myers, and he talked about, he recognized that this is a crisis, this is an emergency. He said that, and he talked about the fact that the May 6th release was actually, they thought it was originally hundreds of gallons, and it was really probably 19,000 gallons. And again, this makes us wonder about their systems on systems about how do they track things? How do they know things? How can we have any
15
confidence?
minutes has elapsed.
Thank you. And he also talked about the tank tightness testing and how that they are not actually capable of telling anything about the maintenance of the facilities. And you can look back on Sherry Ing's and Michael McGinnis's testimony, but I think it bears out the situation that we know. The Navy has told us that they've tried. They want to keep the fuel in the tanks. And they want to address a situation when it happens, and they're willing to put some effort into trying to address a situation after it happens. But what this kind of test run has demonstrated, that they can't do it without harming the people. They can't do it without harming the environment. And so we have to ask you, the Department of Health, to take an action today to make sure that this imminent peril doesn't turn into a catastrophe beyond proportions, a catastrophe that we'll never be able to address. We believe that's your constitutional duty, and we ask that you do it. Thank you very much.
Thank you, Ms. Gannon.